Good afternoon. First and foremost, I want to introduce two of our stellar attorneys that are standing with me today, Hallie Schumann and Christiane Bryant. They compose the heart of our trial team in the parade cases, and I am very, very proud to stand with them and behind them. I also want to start, of course, by recognizing Lisa Lopez Galvan's family. And she went to a parade which was supposed to be a jovial occasion. And unfortunately, she never made it home. Our hearts remain with her and her family and every single person that loved her. I'd also like to address some of the reporting that is circulating right now, because the community definitely deserves the full picture on an issue of so much concern. Frankly, it is irresponsible to simply report that charges were dropped without informing the public of the legal context behind the decision. And some reports have stated definitively that Mr. Miller's gun was the gun that fired the fatal shot. The available evidence has not conclusively confirmed that. You all, and I mean this with all of the respect in my body, we are not talking about a stolen car right now. We are talking about a lost loved one. And the least we could do is try to be accurate on behalf of the family as they continue to grieve. We don't make charging decisions based on public pressure, speculation, or assumptions. We make charging decisions in this office based on what we can prove beyond a reasonable doubt. And because there are other cases pending connected to this matter regarding the same incident, I will not be discussing specific evidence in those cases today. But what I can share is that in complex incidents like this, our goal is to always carefully consider the roles various individuals played. The justice system recognizes that different conduct warrants different consequences, and our office evaluates each person's actions based on the evidence and the law. What we will talk about today are the limitations Missouri law has imposed that allow this case to turn out this way, and why it is a far bigger problem than this instant issue. Ultimately, at the end of the day, voters in Jackson County elected me to follow the law. And that is exactly what this trial team did. The Missouri approved jury instructions clearly state, and I quote, "In this state, the use of physical force, including the use of deadly force, to defend another person is lawful." I'm going to repeat that so I can make sure that it sticks. In this state, the use of physical force, including the use of deadly force, to defend another person is lawful. The instructions also state that the state bears the burden of proving beyond a reasonable doubt that the defendant did not act in lawful self-defense. That is an extraordinarily high burden, and it is a burden that must be respected under the law. Without proof that Mr. Miller was the initial aggressor, Missouri law does not allow us to continue with a murder charge. We consulted with Lisa's family every step of the way, and they understood the limitations placed upon us. Of course, they're not happy. We would never expect them or ask them to be happy, but we did bring them into every single second of this decision that we came to. And frankly, they deserve way more than the law currently allows us to give them. What happened in this case is something that my office and other prosecutors across the entire state of Missouri confront way more than we should. About a month ago, I sat across from another grieving family and told them that we could not file murder charges for the death of their loved one. In this incident, two groups arranged to meet for the purposes of a confrontation. The moment they locked eyes, both sides opened fire simultaneously. We could not determine who shot first. We could not prove who the initial aggressor was. So under Missouri law, that meant that we did not file a murder charge, even though someone lost their life. Those conversations with families never get easier and should not have to happen as often as they do. And that is exactly why my office has been working on these issues behind the scenes, even when it doesn't make headlines. shortly before the end of the year, we convened a meeting here in this office, and I invited both Democrat and Republican lawmakers to our office to discuss a series of proposed legislative changes that would make our jobs easier, that would allow us to prosecute more people, that would allow us to avenge more victims. And last year, my office also devoted attorney time to researching and filing an amicus brief in conjunction with the Missouri Attorney General and the Missouri Association of Prosecuting Attorneys. That brief challenged a court decision that allowed lethal force in response to what began as a relatively minor assault. My administration has never been soft on crime. This office is not soft on crime. We believe in being smart on crime, and part of that means changing the laws that are failing the people of Jackson County and beyond. And as I close and make ourselves available to questions, I just want you all to know that I share and I feel the community's frustration. Losing an innocent person is absolutely devastating, especially a person with such a joyous footprint on her community. But we must be productive and direct our frustration at the laws governing these cases, not exclusively the prosecutors and judges sworn to follow them. We will not file charges we cannot prove just to make a statement. We'll keep working with lawmakers to make tweaks to the laws failing our community. And with that, I am happy to take any questions, but please be reminded, because of the pending cases, we will not comment on specific evidentiary matters concerning those cases.
Melesa, I wanted to ask you about the comment that you just made, that you're not going to file charges just to make a show as opposed to something that you can prove. Yet, in the case that you just talked about with Mr. Miller, you went to a grand jury and you got an indictment on second-degree murder, 2 counts of armed criminal action, and unlawful use of a weapon. And we got rid of 3 of those, and the one that he pled guilty to was actually pled down from a B to an E felony. You folks certainly knew about these laws, the self-defense laws, in advance. So why are you going to a grand jury and asking for something that you can't prove in
Andy,
court?
I will not comment on decisions that were made when I was not in this office. Thank you very much. Next question.
Have you been in contact with the Lopez family at all? Can you tell me that, if you've been in contact with them?
Absolutely.
Can you give me an idea of what that conversation might have been?
Frequent in-person meetings, consultation before the plea hearing, assigning a victim advocate to support the family. We do not make these type of decisions without engaging the family.
I went to a bank just now. A lady asked me, where are you going? Because she knew me.
Correct.
And as I was coming here to the county court to cover this news conference, she said, she needs justice. That family needs justice. I mean, the whole community feels that way.
Absolutely, and we are continuing to pursue justice. Please be reminded that there is still 2 pending trial cases that we are still working on, and that we are leaving no stone unturned to make sure that conduct marries the consequences available to us.
Can I get some clarity on the
you
law?
did 2 more. And Melesa, you mentioned, it sounds as though you're saying your hands have been tied because of the way the law is written. So ideally, you talk about tweaking the law. What would you like to see changed to enable you to be more aggressive in prosecuting these cases?
That is a great question. We recently wrote an op-ed in the Kansas City Star that outlines a series of proposed legislative changes in great specificity. Number 1, something as minor as a simple assault should not warrant the return of lethal force under our applicable self-defense and defense of other doctrines. I encourage everybody to please reread that op-ed.
A lot of people will find similarities between this situation and the Crown Center shooting, when they were able to get armed criminal action convictions, and prosecutors said even with armed with Missouri's generous self-defense laws, we're still able to get that accountability. Can you discuss any differences?
We did get accountability. 2 years in the Missouri Department of Corrections, not being able to ever hold or carry a firearm again. It's not perfect. It's not what we would have desired, but it is accountability. He is now a convicted felon that is barred from possessing a firearm, and we still have other cases that we are avidly working on.
Just to get some clarity on the law, okay, because you're talking about how robust it is, the stand your ground and the changes that you would like to make. So if there's someone who initiates something, anybody who responds can claim self-defense. Is that your
If they are claiming that they are acting in defense of themselves or defense of others. And before I leave you all, I do want to show you a pretty terrifying graphic. Since 2015, these are the amount of cases on an annual basis that we have declined to charge based on self-defense. These are difficult decisions. These are families that are disappointed. These are loved ones that will never be able to say that they received justice. We are happy to circulate this to you, but frankly, this also represents decisions that we did not want to make. And so if we're going to talk about what the prosecutor's office is or is not doing, if we're going to talk about what law enforcement is or is not doing, we have to talk about what the laws allow. And that is the purpose of today's conversation. That is the conversation that we want to ignite and to initiate in this community, because without every single sector of this system operating in conjunction with one another, we will never be able to deliver on the promise of public safety. With that, we will not take any more questions, and we thank everybody for their time.
You getting anywhere with Jeff City at all?